All right, welcome to the deep dive. We're all about making the complex, well, a little less complex, taking those really dense information-packed topics and pulling out the insights that matter.
Exactly. We're like those park rangers who guide you through the wilderness,
Yeah.
making sure you don't miss the really important stuff.
Perfect analogy. And today's journey takes us deep into the world of UK construction law, specifically a pretty fascinating case from the Technology and Construction Court. Home Group Ltd v. MPS Housing Ltd. decided just last year, 2023.
We're basing our deep dive today on the official judgment itself. Gives us a real behind-the-scenes look at how these kinds of disputes play out, within the very specific rules of the construction industry.
So to get started, can you set the scene for us? What was the core issue that sparked this whole legal battle?
Okay, so we have Home Group. They had a contract with MPS Housing for, well, basically maintenance and repair work. Pretty standard stuff in the construction world. Now, at some point, MPS decided, okay, we're done with this contract, tried to terminate it. But Home Group, they weren't having it.
They weren't just a little peeved, were they?
Oh, no, not at all.
Yeah.
Home Group argued that MPS walking away was a serious breach of contract, what's called a repudiatory breach. Basically, they were saying that MPS acted so badly that it completely undermined the whole agreement.
So this wasn't the first time these two had butted heads legally, right? This case we're talking about is a sequel of sorts.
Exactly right. There was a whole other adjudication before this one, and in that first round, it was decided, yep, MPS's attempt to terminate the contract. Totally invalid, and yes, it was a repudiatory breach.
So that's all in the background, kind of like the prequel to our story. Today, we're focusing on the second adjudication, which got into the nitty-gritty of money.
And we're not talking about, like, a few quid here and there. Home Group claimed they'd suffered serious financial losses because of MPS's actions. $6,565,831.94, plus interest, of course.
Oof, that's a serious chunk of change. But to justify a claim that big, they must have had to back it up with a ton of evidence, right?
You said it. We're talking about an absolute mountain of documentation. Home Group presented a 155-page expert report supported by, get this, 76 appendices.
76? Are you serious?
Dead serious. And if you think about that digitally, it was hundreds of files, 338 megabytes of data, and over 2,000 other files, all dumped on MPS.
So basically a data avalanche. And how long did MPS have to sift through all that and figure out their response?
19 days,
Oh,
which, if you factor out weekends and holidays, comes down to 13 working days. Talk about a tight deadline.
No kidding. It's no wonder that MPS ended up challenging the whole thing. They must have felt like they were, set up to fail with such limited time.
That's exactly what they argued. Their main point was that it was simply impossible to properly analyze and respond to such a massive, complex claim in that time frame. They said it was a breach of natural justice.
Now, when they say natural justice, what does that actually mean in a legal context?
Good question. It's essentially the idea that everyone deserves a fair hearing, a chance to present their side of the story properly. And MPS's argument was that with such a huge amount of information in such little time, they were robbed of that basic right.
Okay, so that's the heart of their challenge, but they weren't saying that this kind of financial dispute was automatically off limits for adjudication, right?
No, not at all. They were
Oh.
very specific about this. Their argument wasn't about the dispute itself. It was about the process, the sheer unfairness of it all. The time pressure, the volume of documents, it all added up to an unbalanced playing field.
So they were saying, look, adjudication might be okay for some things, but this was just too much, too fast.
Exactly. They felt the process itself was flawed because they couldn't possibly be expected to respond effectively under those conditions.
Got it. Now, before we get into the adjudication itself, I understand there was a bit of a back and forth between the parties, sort of like pre-trial maneuvering. What happened there?
You're right. So even before that first adjudication wrapped up, Home Group had already sent their final account to MPS.
And that's basically their bill, right? Their final tally of what they claimed they were owed.
Exactly. And it was a hefty one. Over £7.8 million. A big chunk of that was for breach of contract, stemming from those actions we talked about earlier.
So a multi-million-pound bill just lands on MPS's desk. What was their reaction? I'd imagine a bit of sticker shock.
Yeah, you could say that. MPS basically pushed back, saying, whoa, hold on, this is a huge number, and you haven't really given us the details to understand how you got there. They made it clear that they needed way more information to properly assess the claim and figure out their response. They specifically asked for certain documents from Home Group.
So they were saying, show us the receipts. Or in this case, probably spreadsheets.
Right. And MPS even gave a rough estimate of the time they'd need to respond once they got that missing information. About 8 weeks.
8 weeks. Did Home Group agree to that?
Not quite. They weren't too keen on waiting that long. They proposed something they thought was more efficient. A sample review.
Okay, what did that entail?
Home Group suggested that MPS just look at a random 5% of the work orders. These were orders that Home Group had to outsource to other companies to do the work that, well, MPS was supposed to be doing.
So MPS could come to Home Group's office, look at the documentation for just this little 5% sample, and then what?
And then MPS would have a mere 7 days to make an offer to settle the whole thing.
7 days. After reviewing only 5% of a multi-million-pound claim, that doesn't seem very generous, shall we say.
Yeah, it did raise some eyebrows. MPS definitely wasn't happy with that. They pointed out that a 5% sample was way too small to give them a real understanding of the whole claim. They wanted more detail, specifically spreadsheets that broke down every single work order. They asked for at least 8 specific categories of information for every single order.
So spreadsheets galore. Did Home Group cough up the goods?
Eventually. They did provide 11 spreadsheets. And get this, they actually increased their claim in the process.
They upped the ante. Bold move.
Very bold. They also repeated their offer for MPS to swing by their offices and check out a sample of the data. But here's a crucial point. Even though MPS never took them up on it, Home Group actually gave them a draft of their expert report, the same one they basically used in the adjudication almost 2 months before MPS had to submit their official response.
Wait, 2 months? That seems like a pretty decent heads up.
Yeah, you'd think so, wouldn't you? And even though MPS had originally claimed they'd need until May to respond, and they didn't even hire their own expert until late February, they never took advantage of that early access.
Interesting. It's like they were complaining about not having enough time, but then not fully using the time they were given.
It definitely seems like a bit of a missed opportunity. But regardless, the formal adjudication process eventually kicked off.
Okay, so let's get into that. What happened once things got official?
So the notice of adjudication landed on March 13th, 2023. And pretty quickly, an adjudicator was appointed. Very experienced in these kinds of disputes. Almost immediately, MPS throws up a bunch of roadblocks.
Roadblocks, meaning what exactly?
Basically, they're saying, hold on, Mr. Adjudicator. You don't even have the authority to decide this case. They argued a few things. First, that there wasn't a clearly defined dispute yet. Then, that the whole thing was way too big and complicated for adjudication, which is supposed to be a fast process. And lastly, that they were trying to cram a bunch of different disputes into one adjudication.
So challenging the adjudicator's jurisdiction right from the get-go. Did Mr. Pye buy any of it?
Well, initially, he signaled that he thought he did have the power to proceed. And then, he laid out a timetable. Deadlines for MPS to submit their response, then for Home Group to reply, then MPS again with a rejoinder, and finally, a date for him to make his decision.
So, a clear roadmap for how the adjudication would unfold.
Exactly. Home Group was fine with this timeline, but MPS, they formally objected. They weren't happy about the time frame, still maintained their jurisdictional objections. But, the adjudication train kept on rolling.
So despite their protests, they still had to participate.
They did. MPS eventually submitted their response, which included a report from their own expert, Mr. Porter.
And what was Mr. Porter's take on the whole thing, given all the time pressure MPS was complaining about?
Well, right off the bat, he made it crystal clear. The limited time he'd been given made it really tough to do a proper, thorough analysis of Home Group's claims. He pointed out the huge difference between the time Home Group's expert had to prepare their detailed report and the super compressed schedule he was stuck with. Not exactly a level playing field from his perspective.
Okay, but did he offer any alternative numbers? Did he say, look, I think the actual losses are X amount, not Y amount? Or was it mainly just criticizing Home Group's report?
That's an interesting point. Mr. Porter's report focused mainly on poking holes in the approach, the methods, the assumptions that Home Group's expert used. He wasn't really putting forward his own fully developed calculation of what the losses should be.
So kind of saying, here's what they did wrong, but not necessarily here's what the right answer is. Interesting strategy.
Right. But MPS did have their own factual witnesses, and they proposed specific adjustments, deductions to Home Group's claim based on their understanding of what actually happened.
So they were offering some counter-arguments, just not a completely alternative valuation.
Exactly. And it's worth noting that Home Group actually agreed to one of the big deductions MPS proposed, something about potential double counting in their claim.
Okay, so after all this back and forth, reports flying around, arguments and counter-arguments, what did the adjudicator ultimately decide?
Drum roll. Mr. Pius sided with Home Group. He said MPS owed the full amount claimed, $6,565,831.94, and he addressed those jurisdictional challenges head-on. Said that despite the tight time frame, he had enough time and information to understand the core of the dispute and make a fair decision.
Okay, so round 2 goes to Home Group, but this is a legal boxing match, right? And MPS wasn't ready to throw in the towel just yet. They took the fight to the High Court.
That's right. And the big question in front of the High Court was, should they enforce the adjudicator's decision, even with all those complaints from MPS about fairness, the limited time, all that?
So what legal principles did the High Court have to consider in making that call?
Well, first up, there's Section 108 of the Housing Grants, Construction, and Regeneration Act, 1996. That's the law that basically sets up the whole right to adjudication in construction disputes. And then there's a whole pile of case law, basically, previous court decisions that help interpret that law.
So they had to look at the rules of the game and how those rules have been applied in the past.
Exactly.
Yeah.
And the general rule that's emerged from all those cases is that adjudicators' decisions are meant to be upheld, enforced. Unless, and this is important, unless there's clear evidence of some major unfairness in the process, some serious prejudice to the side that lost. The courts are usually pretty reluctant to overturn a decision just because someone complains about the tight deadlines, because speed is kind of the whole point of adjudication.
Right. It's supposed to be quick and dirty, not a drawn-out courtroom drama.
Exactly. But you mentioned a case earlier, White and Mackay. That's often cited as an example where a court did refuse to enforce an adjudicator's decision.
Right. It's like the exception that proves the rule. Can you tell us a bit more about that case and why it was so different?
So in White and Mackay Ltd v. Blythe and Blythe Consulting Engineers Ltd, the court in Scotland decided not to enforce the adjudicator's decision. Why? Well, it was a super complex case, a claim of professional negligence brought years after the construction work was finished. And the court basically said, this kind of case, with all its nuances, all the back and forth, the need for deep analysis, it just doesn't fit with the quick-fire nature of adjudication.
So they said adjudication's great for a lot of things, but not for this.
Right. And the High Court in this Home Group case, they were very aware of that precedent. And they made a point of saying, look, this case, it's not like White and Mackay at all. It's much more like a typical final account dispute, the kind that happens all the time in construction. Employer says, you owe me this much. Contractor says, no way, I owe you less.
So a bread-and-butter construction dispute, even though it involved a huge amount of money.
Right. And here's a key point the court made. They said that MPS's argument that they couldn't do a proper review without detailed info on every single work order, no matter how small that was, wholly unrealistic.
Wholly unrealistic. That's a pretty strong statement from the court.
It is. And they're basically saying, look, we get it. It was a lot of information. But come on, you can't expect to have your hand held through every single tiny detail when you're dealing with a multi-million-pound claim. You have to use your judgment, your expertise, to prioritize and focus.
So they were saying you had to be strategic, you had to be efficient.
Exactly. And they also pointed out, remember, you got that draft expert report way ahead of time, and you were offered access to all the underlying data. But you didn't really make the most of those opportunities. And they went on to say that MPS was able to engage with the heart of the claim. They identified specific areas where they thought Home Group was wrong, where they were overcharging, and they even managed to get Home Group to agree to some deductions.
Okay, so MPS wasn't totally shut out. They made some headway. What about that issue of duplication in Home Group's claim? MPS seemed pretty convinced that there was more double counting going on than the adjudicator acknowledged.
The High Court addressed that directly. They said, look, the adjudicator considered the evidence from both sides on this duplication issue. He made a judgment call based on what was presented to him, and the court basically said that's his job. Even if MPS disagrees with his conclusion, he was within his rights to make that call.
So respecting the adjudicator's role as the decision maker, even if one side thinks he got it wrong.
Precisely. So after all that, what was the High Court's final verdict? Did they side with MPS and overturn the adjudicator's decision?
What do you think?
I think you know the answer to that. The High Court resoundingly said, nope, the adjudicator's decision stands. They rejected all of MPS's arguments about a breach of natural justice, about the process being unfair. They ordered MPS to pay the full amount, the original $6,565,831.94, plus interest, plus a chunk of the adjudicator's fees.
So a decisive victory for Home Group. A knockout punch in that legal boxing match.
You could say that. But what does this all mean for our listeners? What's the key takeaway from this deep dive into the world of construction disputes? Well, for anyone involved in construction, or really any kind of commercial contracts, this case is a reminder. Adjudication is fast-paced, it's high pressure, and when you're facing a big, complex claim, you can't just sit back and say, whoa, I need more time.
Yeah.
Especially if you haven't taken advantage of the opportunities you were given.
Right. It's about being proactive, being prepared.
Exactly. And the court made it crystal clear that you have a responsibility to be on top of things, to engage with the information you're given, even if it's a lot, even if it's complicated, to use those early access opportunities wisely. Because if you don't and you end up on the losing side, the court's going to be pretty skeptical if you start complaining about fairness after the fact. So here's a final thought for our listeners to ponder. What if MPS had been more proactive? What if they'd taken Home Group up on those offers to dig into the details way before the adjudication kicked off? Could they have changed the outcome? Or, think about it this way. If you're ever facing a similar situation, a huge claim, a tight deadline, what strategic steps should you take right from the start to protect yourself? What are the key moves in this high-stakes game of construction adjudication?
It's a fascinating question because it really highlights that tension between being thorough, really understanding all the details, and the need for speed for making decisions quickly in the fast-paced world of business. Adjudication is trying to balance those competing demands, and this case shows just how tricky that can be.
It absolutely does, and it's a tension that exists in all kinds of commercial disputes. So, listeners, think about it. How would you navigate that tricky terrain?
That's all the time we have for this deep dive. Thanks for joining us, and we'll see you next time.
See you then.